SJC-11763, Commonwealth v. Elvin Bastaldo.
Good morning, Mr. Levin. When you get settled, you may begin.
Thank you, Mr. Chief Justice, and may it please the Court, Patrick Levin, representing Elvin Bastaldo, who appeals today from convictions of mayhem and resisting arrest in the Springfield Superior Court. My primary contention on appeal is that the trial judge erred in refusing to give an instruction on cross-racial identification at trial.
Would you agree that the standard at the time was abuse of discretion?
Yes, I would, Your Honor, and I believe the judge did abuse her discretion in this case. The research, I think, has been plain for some time now.
Could I just ask you if you could give us, before you get into that, because I think there was some confusion in terms of, I saw the written instruction that was presented, which talked about both race and ethnicity, as I recall. But the argument, I mean, the discussion with the judge was really, seemed to focus, at least in fair part, on ethnicity. And so does that make a difference here in terms of what the judge was thinking about?
I agree
What's the
that
role
in
of that?
addressing the request, the judge did seem to focus on ethnicity.
Well, that was not, I mean, wasn't that was what was being argued by, I don't think, were you trial counsel?
I was not, no.
Yeah, but by trial counsel?
My recollection is that trial counsel explicitly argued both race and ethnicity. I may be misremembering that from the transcript, but in any event, the instruction that he requested made reference to both race and ethnicity, and I think that that is the appropriate way to give this kind of an instruction, and I think that this case well demonstrates why that's the case, because by any reasonable definition, the identifications in this case were cross-racial. But it's clear that there's some confusion about what these terms mean. And the research, I think, is most fairly read to show that this effect kicks in when the eyewitness and the suspect are visibly members of visibly different groups, a racial or ethnic difference that is physically manifested. And because of the confusion in terms of what the words, specific words, race and ethnicity may mean, I think the clearest way to communicate to the jury what the research has found is to simply say race or ethnicity, and then the jury will best be able to understand what we mean.
So have there been studies on ethnicity, cross-ethnic identifications?
Well, I think the fairest answer to that is that the studies don't distinguish very strictly between race and ethnicity. Many of them seem to use the words interchangeably. I'm aware of studies involving Mexican Americans, involving white French and German subjects, involving Koreans and Japanese, involving Canadians, Native Americans, members of the Canadian First Nations, and obviously white and black Americans. I'm also aware of a study that found the effect among Sephardic, Ashkenazi, and Arab Jews in Israel.
So on this point about the race and ethnicity, the proposed instruction that is in Gomes just says racial identity. Do you think that it should be, your comment, should you write it, would be you need to expand it to be race and ethnicity?
Yes, I believe so. I think that by only mentioning race, there's a potential to confuse the jury as to what the research actually shows.
But ethnicity can be Italian versus Irish.
That's right, and so it may be appropriate to inform the jury that what we mean is
physically manifested differences.
Right, different racial or ethnic groups where such a difference is physically manifested.
Was the defendant's color established in some kind of official way for the judge? I mean, was she thinking that this defendant is black and two of the identifying witnesses were white, although the victim and the defendant were both Hispanic?
I can't speak to what Justice Sweeney was thinking, but I mean, I can say that Mr. Bastaldo obviously was there before the judge and the jury. He testified at trial. He was there on the stand. And so his complexion would have been apparent to all of them. And I would also say that Mr. Keniston, in describing the assailant at the scene of the crime, his testimony strongly suggested that he did view that person as black. And I guess the other thing I'd say is that I note in my reply brief that during jury selection, a member of the pool did say that he would not be able to render a fair verdict in the case due to an assault that he witnessed that had been perpetrated by, his words were, 3 black guys, I believe, which also suggests that he perceived the defendants as black.
Now, in terms of abuse of discretion, in Gomes, we said the judge was not given an appropriate foundation in which to make the finding that it was clearly established. Was there any foundation given to this judge?
In the form of scientific studies, no. In the form of citations to Massachusetts appellate cases, yes. And there are a number of cases now that recognize that this effect exists and is robust. As far back as 1999, the appeals court in Commonwealth versus Jean-Jacques has been directing trial courts to consider a request for this instruction with the language as a measure of favorable inclination to grant it.
And we have a number of our cases as well.
And in Hyatt and Bly and Justice Cordy's concurrence in, I believe it's Commonwealth versus Zimmerman, the research is well recognized and appropriately summarized. And the instruction,
even with all that, the law still, as of the day that she decided what to do, was still, you have the discretion whether to give it.
That's right. And Justice Sweeney is clear from her comments, was aware of the study group's report and recommendation that had issued 6 months prior to this trial and acknowledged the existence of a consensus on cross-racial identification.
But not on ethnicity.
No, that's right.
And she was basically doing this, as I recall from her comments or from the transcript, or I'm not sure, but if the record reference, let me put it that way, that she was more concerned with the Hispanic aspect.
Well, to the extent that she failed to recognize that Mr. Bastaldo was black and the 2 eyewitnesses were white, I simply would say that's plain error. And I also would say that this instruction would be appropriate in a case like this, and I think it's going to be a rare case, where there is a dispute as to whether the identifications are cross-racial. I think it would be appropriate in every such case to give the instruction. The jury are in the best position to evaluate whether the principles would apply in such a case.
So the jury would be instructed to first determine whether this was a cross-racial identification?
No, Your
And
Honor.
if it was,
The
then-
jury simply would be instructed that members of all races and ethnicities have greater difficulty in identifying members of a different race or ethnicity, as such differences are physically manifested, than a member of their own race or ethnicity, and that that's a factor that they may consider in determining the accuracy of the identifications in the case before them.
Now, that was objected to, but some of the other issues relating to identification, as in the comment of the police officer to Mr. Keniston, it said there was no objection to that. Is that right?
That's right. Those issues are unpreserved, Your Honor. But my argument is that the admission of the in-court identifications in particular by the victim and by Mr. Keniston violated Mr. Bastaldo's due process rights.
Not objected to.
Not objected to, that's right. And it's a separate due process violation, and I argue it did create a substantial risk of a miscarriage of justice, given that it was the bulk of the identification evidence in this case, and given the strength of especially the victim's identification, where he repeatedly testified that he would never forget the face of the man who did this to him. I know the Commonwealth, in passing in its brief.
Well, your client admits that he was there, so
Yes,
this
that's
isn't
right.
a question of way out of whack. And didn't Mr. Kennison testify that he actually watched the defendant flee and then saw him tackled by the police?
Well, Your Honor, that's a possible reading of Mr. Kennison's testimony. It's not entirely clear in his testimony, but the jury would have to decide whether they found that credible, even if they decided that's what he meant. And I would say that description of the events is inherently implausible, given the other evidence in the case, where the officer who was closer to Mr. Bastaldo when he was arrested said that he did lose sight of Mr. Bastaldo before the other officers were able to apprehend him, and where Mr. Kennison himself testified that on his way back out to take the victim to the hospital, he actually asked the officers whether they had caught the guy. And I guess the other thing that I was going to say, as
3 identifications,
right,
made in a well-lit area, or at least that was the evidence.
That was the evidence.
One by a police officer who was threatened, "I'm going to F you up," by this guy, I suppose just feet away. Another by the victim who was assaulted. A third by just a person who was a bystander at the time. And the defendant is arrested, what, a few blocks away, fleeing the scene?
Approximately a block away, I think.
Block away, fleeing the scene.
There's no testimony that he's arrested.
And he's the
fleeing
brother
scene.
of
The arresting officers didn't testify at trial, and so the only evidence we have is that the defendant was walking home. That's from the defendant's own testimony at the time that he was apprehended.
Well, I take it the witnesses saw him fleeing the scene. No, Mr. Kennison didn't say he saw.
Well, that presumes that their identifications are accurate, Your Honor.
They saw somebody fleeing the scene.
They saw the assailant fleeing the scene.
And was there evidence in terms of how soon after, let's just take Mr. Kennison saw the assailant fleeing the scene, how soon thereafter the arrest was made, or he was stopped and brought back?
I believe the evidence is that it was pretty quick after.
Within a minute, something like that?
Yeah, within about a minute, I believe, is the evidence that he was brought back.
Counsel, I have a question about your consciousness of guilt argument. When the judge gave her consciousness of guilt instruction, did she say to the jury, if you find that the defendant was the person who fled, or did she
No, Your Honor.
specify?
I believe what she said was that there was evidence that Elvin Bastaldo may have fled the scene after assaulting the victim, or something to that effect. I don't have the language right in front of me. Her instruction comported with Commonwealth versus Tony to the extent that she said that, you need not find that this conduct demonstrates consciousness of guilt, and need not find
Right, but it was assuming that the person who fled was the defendant.
That was, I think, an inherent assumption in that instruction, and as I note in my brief, also in her joint venture instruction, where she repeatedly instructs that they can only convict Juan Bastaldo if they find that he was engaged in a joint venture with his brother Elvin. So that her instructions, I think, as a whole...
Why is that a problem?
Yeah.
Because it presumes that the assailant was Elvin, which is the question for the jury in Elvin's case.
Now, the Commonwealth also suggests that the fact that the defendant fled from the scene was not in genuine dispute.
Frankly, I don't understand that contention, Your Honor.
Okay.
I thought your client said he walked away from the scene.
That's
That's
right.
different than
scene.
fleeing, but your point is that's different than fleeing.
Yes.
Well, that's for the jury to decide, isn't it?
This court's decisions make plain that walking away from the scene of a crime...
Walking away from the scene where your brother is on the ground, I mean, isn't the jury able to determine whether that means he was trying to get out of there because he had been involved?
Your Honor, all I can say is that the decisions of this court make clear that walking away is not flight, that they mean different things. And you can look at decisions not only of this court but of the Supreme Court that say that nothing is to be presumed from someone walking away from the scene of a crime just because they may fear being wrongfully apprehended. They may have good reason to not want to speak with the police that has nothing to do with their guilt whatsoever.
So you're suggesting that the instruction as given, which wasn't objected to?
It was objected to, Your Honor.
Objected to it, okay. So the reason for the objection then, and your argument is that there wasn't distinction made between a person walking, the walking away by the brother, which is not contested, as compared to the fleeing assumed assailant, which you're saying
well,
wasn't
the
same.
instruction would have been erroneous even if that distinction had been made, because there is no proper inference of consciousness of guilt that can arise from walking away from the scene of a crime.
How about walking fast?
Or running. I mean, you had,
Running or throwing
you had
something.
Keniston said that the assailant ran and that he saw him captured, and we know who was captured.
Your Honor, that's a circular argument. It requires you to accept the...
No,
It
basically
requires
it becomes chain of custody. If Keniston says, I saw this person hit him, then I saw him run, then I saw him being arrested, then there's no ID. It's the person arrested was the assailant who ran. That's almost a chain of custody issue, not an ID issue.
Well, Your Honor, as I said, I think that obviously the jury had to be in a position to evaluate Mr. Keniston's testimony.
Right, I understand that, but if Keniston is credible, there is evidence that the assailant, whoever it was the person who was captured, because Keniston saw the person assault and then saw him run and then saw that person be captured.
Your point, I think, I mean, that's all true, but I take it your point is maybe, but for the judge to assume that was the problem.
Well, yes, that's precisely right, is that the judge's instructions, both on joint venture and on consciousness of guilt, assumed that Elvin was the person who had assaulted the victim in this case and communicated to the jury that the judge had made that assumption.
You mean she didn't present it that you may have heard evidence that the defendant fled? Usually the consciousness of guilt instruction is not defendant specific. It's worded generally. You may consider such evidence.
She used the defendant's name in the instruction, Your Honor.
Okay.
If there are no more questions, I'll rest on my brief. Thank you very much.
Good morning. May it please the Court. Bethany Lynch, Assistant District Attorney representing the Commonwealth. If it please the Court, I will start with the issue of the cross-racial versus cross-ethnic identification.
And before you get there, why are you opposing the introduction of his photo? How are we supposed to know that he's black without the photo?
Yeah.
I'm sorry? How are we supposed to...
How are we, not you, how are we supposed to know that the defendant is black without seeing the photo which the defendant wishes to...
Well, I would argue that the defendant isn't black, that he's Hispanic.
Well, just to see what he looks like, whether you want
The
to...
judge below could
Yes.
see.
Well, I
And the way the jury
would
could see.
argue that the photograph itself was not part of the record, and so that is why we opposed it. The authentication of it, I would argue, was not part of the record. It was a photograph that was presumably taken at some time prior to his arrest.
You couldn't agree upon a photo that could become part of the record?
I mean, we just are, the issue in the case, I understand.
I understand. No,
This
I
is
do
an
understand.
issue. The judge sees the person, the jury sees the person, we don't. So,
Which is why there could have been a description on the record, or there could have been a proffer on the record by the defendant who was trying to make this claim. He's obviously was trying to make a
It's
foundational
a
claim.
hyper-technical thing that you're doing here.
It might be. It may be, Your Honor. But at the time, I felt that the motion to expand the record was an inappropriate avenue to place a photograph that was not before the judge for her consideration onto the record. That I felt that it should have been on the record as part of the trial record and not to put it on after the fact using Rule 8 to add evidence that was not before the trial judge.
But wouldn't it matter if he were Hispanic but of European ancestry? I mean, we have Hispanics who are from...
Well, I would have opposed the photograph regardless. I didn't oppose it based
Apart from your
on...
opposition, doesn't it matter to us in terms of deciding this case?
I would
whether
argue
this
that
defendant was of European ancestry, of African-American ancestry, or of...
I would argue that the evidence in the case demonstrates that he's of Hispanic ancestry.
Yes.
And that Hispanic is not
What
a
race is he? What race is he? Never mind ethnicity. What race is he?
I would argue that as a Hispanic, that his race is considered Caucasian.
No.
for the purposes of
That's the
jury
problem with
instruction.
this case, because
and it
that
may
is
be.
just an incredibly astonishing assumption that everybody who is Hispanic is Caucasian. Where does
Is
that come
Caucasian,
from?
as I would argue that that's the case law of Massachusetts, is that that Hispanic is considered Caucasian for racial purposes. I would agree completely that it's a different ethnicity.
But but just real life. You know that's not true. I mean, not every Hispanic person of Hispanic ancestry looks like you or me.
And that is true. But for the purposes of whether a jury instruction that would mandate that a jury look at this differently, I would suggest that the social science that supports this does not, there hasn't been sufficient social science in the area of Hispanic versus Caucasian, or versus
but there has
white,
been
like European.
with regard to African American or race.
There has
Black
been.
African American, let's keep white South Africans out of it, but I mean, the fact of the matter is, people came to Latin America from Spain, and they came from as slaves from Africa, and there were many who were native to it who look different. So there are at least 3 different races who are Hispanic. And you say we should treat them all as black?
I would say that for the purposes of this discussion and for
as white? I mean,
for what was in front of the judge at the time, the defendant was Hispanic. He was identified as Hispanic by 3 witnesses.
But she could see him, and so could the jury.
But is that, so the judge's determination needs to be based on her assessment of the skin tone. And I mean, that's what we would be asking, is if the skin tone wasn't significantly different enough, then she would or would not have been required to give this instruction. Or it was an abuse of her discretion to decline to give the instruction. In this case, all the evidence was that this defendant was Hispanic. He was identified by another Hispanic gentleman and 2 white, light-skinned European witnesses.
But he said, I'm black, and I want a cross-racial identification instruction. Why couldn't the judge accept that? He's self-identifying.
I would argue that...
Why does she have to put her label on him when he's self-identifying?
I would argue that he didn't self-identify as black. He identified himself as Hispanic, and that he testified in Spanish.
So why is he asking for a cross-racial
He asked for a cross-racial
identification
/
instruction?
cross-ethnic. He asked for cross-racial / cross-ethnic. So he was trying to categorize himself as both to get the benefit.
But the
Because
witness
he is both. He is both.
You
But
can be both.
that's the difficulty in this situation, is to mandate that all Hispanics or all different, if the witness and the perpetrator or the defendant are not of an identical ethnicity, they would be entitled to this instruction. And there's so many gray areas, if I may say, in between what is an ethnicity and what is not an ethnicity, and varying skin tones amongst, that the social science as it stands right now has only examined the difficulty between white and African American in identification. And that is what the social science upon which this instruction is based is founded on.
So why are you less African American because you came from Latin America than if you came from North America? You're still African something.
I would suggest that the race as it has been defined is defined in terms of African American versus Caucasian.
An American meaning U.S.?
I'm sorry, African American in terms...
I'm saying, as to the American part, I mean, there were slaves brought who did sugar in Cuba. I don't understand why American means only United States.
I don't know about whether the studies have gone beyond that. I'm focusing on the social science studies that we rely upon in order to determine whether or not a cross-racial identification instruction is appropriate. And here we would be instructing a jury that, based on social science that this court at this point has yet to completely accept and has yet to declare to be so generally accepted, that as to allow us a jury instruction to be given without any foundation within the record.
But does it matter that the judge herself said that there's a consensus as to cross-racial?
She was going based on the study group report, which reported a consensus. And I would agree that the study group report does report a consensus. The trial judge also made a differentiation between the ethnicity and the race of this defendant. And she found that she categorized him, and seeing him in person, she categorized him as Hispanic. She categorized one of the eyewitnesses also as Hispanic, and the other two as light-skinned Caucasians. So in her assessment, this was not a cross-racial case. This was a cross-ethnic case.
And we can't tell whether she abused her discretion because we don't have a photograph.
I mean, technically, you do have a photograph because it's in the record as part of.
You've opposed it being in the record.
I do. But I would argue that you should be able to rely upon, apart from the photograph, you should be able to rely upon the record as created by Judge
Wasn't there
Sweeney.
also a testimony from a witness that the assailant was black? And there's also part of the record that a juror who was not selected basically said that he would have trouble with, or because of a brawl
He said
with
he would
blacks.
have trouble being impartial because he himself had been attacked.
There's suggestions in the record that that to the extent that this defendant was the assailant, he was black.
There was the suggestion by, I would agree, there was a suggestion by Mr. Keniston that he was uncomfortable categorizing him because he wasn't sure. So he said he could be black, he could be Hispanic, I don't know. As for the juror question, it was a question about, I believe, about bias, and he said that he was unsure that he could be unbiased because he himself had a run-in he had been beaten up by 3 black gentlemen.
Well, he did mention, it was because,
I
I
he'd also
infer
been
from that
beaten
it's
up.
because, yes, but I do infer that he mentioned it because of the black was the salient
He could
feature.
have, or he could have mentioned it because he had been the victim of an assault, as this victim had been, or that, and he could have been saying minority versus, I'm not comfortable with minorities. We don't know. And I think that this is a case where I would suggest that a motion for new trial may have been more appropriate, may have been an appropriate avenue to take so that this information could have been more sorted out. In terms of exactly what the trial judge was saying. She was looking at this defendant who was clearly Hispanic. As to the degree of his skin tone, I would rely on what the judge said rather than rely on a photograph taken. Because I don't know the conditions of the photograph. I don't know, and I personally didn't see him. I didn't see the defendant, I was not trial counsel. But the trial attorney, the defendant's attorney, he established for the record that this was a Hispanic defendant. He didn't ask the questions, he didn't try and lead or do anything to have the witnesses say, well, he was a very dark-skinned Hispanic, I could have thought he was black. There was none of that information in the record. His eliciting of information for the foundation for his request for the jury instruction was that the defendant was Hispanic. He had the witnesses self-identify and then identify their own race and ethnicity, and he had them identify the defendant, and the defendant himself also stated that he was from the Dominican Republic. He testified in Spanish, so he clearly was of Spanish ancestry. And so his eliciting of evidence to support his request was not an attempt to elicit testimony that the defendant was black. It was that he was Hispanic. And as far as the case law at the time that this case was heard, Hispanic is considered Caucasian. It's a different ethnicity, and the social science has not supported. There's no case law that I could find nationwide that mandates a cross-ethnic instruction. There is case law especially from, say, the state of New Jersey and the most recent Oregon case and the cases cited within the study group report that recommend and recognize cross-racial as an issue.
Well, the study group report says puts them together.
It does, but all of the social science upon which it relies goes only to the issue of race. There is no social science that I am aware of that says in any kind of a definitive, generally accepted way that cross-ethnic identification is so well accepted that it should be the basis for a jury instruction.
Let me ask you this. Let's assume there was a case next door to this. Similar facts, except in that particular case, there was no dispute that the defendant was black. Request for cross-racial instruction. Abuse of discretion for a judge not to give it?
At the time?
Yeah.
At the time.
I would suggest that you would probably need more facts, but I would say that it wouldn't be necessarily an abuse of discretion, but I think that in this case sheds light on that, in that the reason that it wasn't given here was because she found the cross-ethnic portion. I would suggest that in this case, and I would suggest most likely in other cases, upon request, unless there was some reason not to give, I don't see that a judge would deny it.
But here it was denied.
Well, here it was denied because she did not find it was a cross-racial identification.
All right, but that's a matter. I mean, we're in a strange position. That is a matter of fact finding.
Exactly, which is what the judge was uncomfortable with.
And so
in
the
part
question
here.
then is whether that's, in terms of reviewing it, whether that's clearly erroneous. Is that something that we would be reviewing on a clearly erroneous standard?
It could be. It's the problem, I would suggest, with the cross-racial versus cross-ethnic and the cross-racial identification instruction in general, is who makes that determination. The instruction as read, I do not believe that the instruction as this court put forth in Gomes reads, if you find cross-racial. It may, and I could be wrong about that. But so does then the jury need to make a factual determination about cross-racial? Someone is making that factual determination.
I don't think that it does. I just think the instruction says if this is an issue, and then it just says that.
So at some point, a judge needs to make a determination that it is in fact cross-racial.
Or that you're entitled to the instruction.
That you're entitled to the, well, yes, and that implicitly finds that if the judge were to find that you were entitled to the instruction, that implicitly finds that she found that it was a cross-racial identification case, and that therefore the defendant, the identified person and the witness were of different races.
But, you could have people who self-identify as African American, even if they are light-skinned or if they have white lineage to any extent, for very good social and cultural reasons. I mean, this is not an easy question, but
that's why.
But I don't know what the studies even say about cross-racial identifications in instances where.
I don't know that the studies have delved into those types of questions, which is why I think that the instruction on a certain level can be troubling, because it's instructing a jury that if there's cross-racial, or this case involves a cross-racial identification, and therefore you can look at it under the light of a difficulty in identifying people not of your own race, but then there are all these preliminary questions to get there. In terms of how light-skinned do you have to be not to qualify for a cross-racial?
Well, how about if somebody just self-identifies? Why couldn't we settle on that? Let people self-identify.
If I were to self-identify as African American,
okay, you self-identify,
would I therefore be entitled?
I would say if you self-identify, that should be enough, and then it's for the jury to decide whether looking at you would make a difference.
I would merely
What's wrong with
suggest
that rule?
that the instruction is based upon social science studies that show that there's a difficulty in that, and that the social science
We're
wouldn't.
just talking about whether the person should have the right to ask for the instruction. We're not to the judge's exercise of discretion to grant it.
Certainly. I mean, they can certainly ask for the instruction. I thought that you were are they entitled to actually receive the instruction?
No, I'm saying
yes, certainly. If they self-identified and said, I'm African American, then yes, they can ask for it. But at that point, If the judge has no discretion and has to give it upon request, that's where I now would challenge their right to actually just be granted.
Well, the judge
right.
would have to accept whatever somebody self-identifies as, but the judge can still make the legal decision about whether the instruction should be given in a given case, but the judge wouldn't have the right to say, I reject your self-identification, would she?
I suppose the judge could say, for the record, your pigment is white.
Yeah,
And,
I wouldn't say that she would outright reject it, but I would suggest that she would definitely put on the record that I do not. I honestly don't know, and these are part of the sticky problems that this instruction and taking the cross-racial instruction, which the court has in Gomes has suggested be given, and then extending it far beyond a differentiation between race into ethnicity, and there are lines to be drawn all along the spectrum, and that's part of the difficulty of this instruction and why the judge in this case did not abuse her discretion in drawing that line and saying there's no evidence for me to present a cross-ethnic identification at this point. The court has no further questions.
Thank you. Actually, there's one thing in terms of, we do have a motion, and you said you haven't. Can you confer with the trial court judge and determine whether there's a challenge to the authenticity or whether that's a fair and accurate reflection of what he looked like at trial to assist us in determining whether or not
Well, I know that the defendant filed his motion, I opposed the motion, and the judge denied the motion to expand the record, and that is part of the motion on appeal.
Could I ask you, actually, a little variation of that? Could you confer with the trial counsel, the prosecutor, and get his or her, I can't remember.
Yes.
His assessment of whether that's a fair and accurate representation.
I can do that.
Because if it is, I would like to know that.
Would you like me to submit that in a letter?
That'd be great.
Would that be fine?
That would be
Yes,
helpful.
I will do
That's
that.
what I
Thank you.
meant to ask. Thank you.
Thank you.